Welcome to Washington Legal Foundation's webinar. This is our 10th Tech in the Courts program that we jointly do with our friends at TechFreedom. I'm Glenn Lammy. I am the Executive Director and Vice President of Legal Studies here at the Foundation. For those of you not familiar with WLF, we are in our 49th year of legal policy advocacy and education on a pretty broad range of issues. TechFreedom is similarly a nonprofit organization that works primarily in the tech space on issues like antitrust, social media, and others. I'll let Bilal tell you a little bit more about them. Let me introduce Bilal. He will be moderating our discussion today. He is a senior competition counsel with TechFreedom. He's most recently the director of the Office of Policy Planning at the Federal Trade Commission from 2018 to 2021. When he was there, he was an attorney in private practice representing clients in merger and non-merger matters before the Commission and the Department of Justice's Antitrust Division, and in consumer protection matters before the Commission as well. He has taught antitrust law as an adjunct professor at the Antonin Scalia Law School at George Mason University. He just said while we were talking here that he's also teaching at Arizona State University this term. And he was also an attorney advisor for the chairman of the FTC, Tim Muris, from 2001 to 2004. We're happy to take your questions if you have any. There's a Q&A console in the toolbar of the Zoom webinar screen, and please use that to ask the questions. The program is being recorded. So with that, I will hand over the proceeds to Bilal.
Glenn, thank you. Thank you very much. And Jay and Barak, thank you for being here. So as Glenn mentioned, I'm Bilal Sayed. I am, among a few things, a senior competition counsel at TechFreedom. TechFreedom is a legal policy think tank that participates in the debate on competition policy, communications policy, First Amendment policy, and some related areas. With me joining the podcast are, as Glenn and I both mentioned, first Barak Orbach, who is the Robert H. Mannheim Professor of Law and Business at the University of Arizona's James E. Rogers College of Law, and he is also a special advisor to Arizona International, the University of Arizona's Global Affairs Division. I won't go into much more detail on Barak's resume, but I will mention that his personal website includes the materials he uses for his antitrust class. And before we joined the podcast or joined the webinar as a group, I was commenting to Glenn and Jay how wonderful the materials are and how much effort they reflect by Barak, and even love of both the discipline and the students and teaching. So as a source of antitrust materials, I would direct you to Barak's personal website. Also joining is Jay Ezrielev. Jay and I worked together at the FTC in the first Trump administration. Jay was an economic advisor to then FTC Chairman Joseph Simons, and he is now the founder and managing principal of Elevecon, which is an economic consulting firm. He specializes in the economics of industrial organization, econometrics, and antitrust policy. And before joining the FTC with Chairman Simons, he was at international economic consulting firms of the highest quality. So with that, we are all here to discuss the final recommendation by the California Law Revision Commission to the state legislature, California state legislature, that California adopt an anti-monopoly and single firm conduct law that, at least in its recommendation, departs significantly from either the approach of federal law, the text approach, or the development of federal single firm conduct law, and may, if adopted, or will, if adopted, have serious and significant effects on the evaluation of single firm conduct and the ability to engage in certain conduct that for many years, many of us have believed was both pro-competitive and efficient, and perhaps in part responsible for the development of globally strong competitors in the United States. So let me sort of kick us off. The recommendation, I think, proposes three or four key guides, key prohibitions. First, the recommendation of the commission includes a recommendation that the state of California adopt a single firm restraint of trade law, right? So basically an analog to Sherman Act Section 1, but removing the requirement of two or more persons agreeing to conduct that restrains trade or unreasonably restrains trade. As Barak reminded me earlier today, this is really a effective repeal, direct repeal of the Colgate Doctrine, which allows a firm to decide who it may deal with. Second, the recommendation proposes the adoption of a Section 2-like statute at the state level, largely adopting the language of Sherman Act Section 2, prohibiting monopolization, attempt to monopolize, conspiracy to monopolize, also adds a prohibition on monopoly maintenance, and also makes clear through statutory language that prohibitions on monopoly or monopoly conduct include conduct that would monopsonize or attempt to monopsonize a relevant market. More specifically, the recommendation provides judicial guidance that directs the state courts, or would direct the state courts, to reject certain Supreme Court opinions, including Brook Group, which deals with predatory pricing, Aspen Ski, and Trinco, both which deal with the legal framework for evaluating duties to deal with other firms, including competitors. The judicial guidance would also reject the market definition principle in Amex around the requirement to include both sides of a platform in the relevant market definition under some conditions, a simultaneous transaction platform. And although not expressed directly, the rejection of both Brook Group and Trinco would appear to revive the price squeeze concept in monopolization law that was either narrowed or perhaps rejected in the link line matter. And then the recommendation also rejects the use of the no economic sense test and/or the equally efficient competitor test as a framework for resolving many monopolization claims. They also reject, the recommendation also rejects out-of-market balancing and inclusion of out-of-market balancing of out-of-market efficiencies with competitive harm. So with that as a quick summary, I'll just note one or two of the justifications, right? The commission believes a state single firm conduct law is necessary because federal doctrine is insufficient to keep up with changes in the economy, and also because of a lax approach to monopolization conduct or cases by the federal antitrust enforcers and related because unfavorable doctrinal development by the Supreme Court with respect to the position of plaintiffs. So, with that as a summary and background, maybe too much. Jump into it, and let me first ask both Barak and Jay, what do you think is the current state of federal antitrust monopolization law? And I think I'd ask you to take account of both the enforcement record and the development of Section 2 law. Are there limitations or deficiencies that affect the enforcement record, or which party is likely to win a case? So Barak, why don't we start with you?
Thank you, Bilal. So I think that there are two separate things. People can have disagreement over the state of Section 2, and these have been significant. I personally think that it could be done, that we should separate between the doctrine and enforcement attitudes. And in my mind, there should be no doubt that enforcement attitudes were too lax. I don't think that today we can say that they are too lax. In terms of doctrinal development, I think that the issue is not that the current doctrine are too lax, but rather that we are missing standards for powerful intermediaries. Traditional antitrust law focuses on the relationship between sellers and buyers, while we do not have either sound economic model or robust economic models for intermediaries, even though we do have some models, and let alone we don't have legal standards. So that's kind of the general key scheme in terms of the actual law. In terms of practicality, I think that the state of California is a little bit out of touch with reality in the sense of, well, someone needs to operate the law. They do not enforce themselves. And these are really complicated cases, really expensive. I don't think that the state of California has the talent, let alone the resources, to address such cases. But that's my personal view.
Okay. Jay, any reaction either to
So,
Barak's
so I don't completely agree. So let me first talk about Section 2, the state of Section 2 enforcement and doctrines. I think that there are some problems, but they're not the kind of problems that California has identified. I think that Section 2 continues to be too vague. I think it's internally inconsistent. I think the rules are not clear. 125 years after the passage of the Sherman Act, we're still debating what antitrust means, what the goals are. I think there is a question about people are still debating what is the goal of antitrust. And before we can talk about whether Section 2 enforcement is successful or the enforcement is too lax or just right, we should think about what is it that Section 2 is supposed to achieve. I think there is disagreement about that. I think, in my view, Section 2 is supposed to be about keeping the markets free for competition within certain bounds. Market participants are supposed to do as much as they can to deliver value for consumers or their customers and generate value in the process. I think that maybe what some of the critics of Section 2 are concerned about are the outcomes where some firms have become too successful, too powerful, they wield too much influence. But that's not, to me, an antitrust issue. This is something completely different, and the antitrust is not a solution. As far as whether there is insufficient enforcement, I think that's or the outcomes of enforcement have been bad. I think for the most part, the markets are pretty free. Firms are pretty, good at innovating, generating value, giving something of value to consumers. And to me, the biggest problem is that there's too much uncertainty. I think that where Section 2 can be improved is in having more certainty, more guidance about what are the bounds of conduct. And if anything, California makes this problem much, much worse. The single firm conduct proposed legislation greatly exacerbates the problem of uncertainty.
So
Barak, can I step in?
Yeah, sure. Barak, go ahead.
So I just want to say that what Jay said is a common way to describe antitrust. I don't think it is closely related to the way courts actually administer antitrust law. So as administered by court, courts generally avoid defining competition because it has many meanings and very often it operates in multiple dimensions. As applied by courts, harm to competition means some reduced of rivalry with some negative effects on trading partners. So there must be the negative effects on trading partners must be tied to reduced rivalry. In the context of Section 2, this normally means foreclosure. And I think that courts have been very, very persistent in this kind of framework over the past at least 10 years.
No, I think we'll come back to the to that framing. I would like in the first instance to talk about the adoption or the recommendation of the adoption of a single firm restraint of trade clause or prohibition, right? I think the three of us, the four of us, all the attendees are familiar with Section 1 of the Sherman Act. California has a rough equivalent of Section 1 of the Sherman Act and the Cartwright Act. Both prohibit agreements in restraint of trade. Both adopt the perspective that what they prohibit is unreasonable restraints of trade by agreement. The Commission's recommendation includes modification to that concept of agreement to prohibit a firm, single firm, from restraints of trade without clear guidance on how to think about unilateral conduct that restrains trade in a manner distinct from monopolization or monopoly conduct. My sort of reading of this prohibition is it is basically a lessening of a burden on a plaintiff to show a harm from conduct, unilateral conduct. So, Barak, let me ask you to sort of react to that. This is the I'll call it the rescission or rejection of the Colgate doctrine. I think that a firm, except in what you might call extraordinary circumstances, has the right to decide who it deals with. But is that the right way to think about it? And is it correct to think about this as really swamping the monopoly power requirement in the usual single firm statutes or cases?
So correct or incorrect, it's a matter of opinion because clearly those who drafted it would think that this is correct. I happen to agree with you, and I'll divide it into two parts, the answer. A, American antitrust law was built on some borrowing of the law of restraints of trade from the English law of restraints of trade. That was the origins, and much of that has evolved of that. And the law of restraints of trade is about that, one party can tie another party contractually. This is the origins. Based on that origin, we received Colgate, which basically say that as a general rule, businesses are free to choose with which party with whom they are going to trade and on what terms. Again, this is given your power, but that's Colgate doctrine. Even though it is counterintuitive and controversial, it is basically very consistent with the origins of antitrust, and it is possibly the most settled doctrine in antitrust law. So those who dislike it should kind of try to think about how to address it. But in my mind, Colgate is the default legal standards of antitrust. Which is quite significant to say this is the default standard. That said, again, I mean, beside the economics of the issues, how are they going to implement a legal standard restraints of trade without any kind of a framework? So the present rule of reason has evolved over many years and significantly over the past 25, 30 years when we had the burden shifting framework. This is kind of a new whole territory. What does it even mean, unilateral restraint of trade? So I think it is in conflicts with the logic of antitrust law, and I don't think that it can be implemented as a practical matter because we don't have the expertise either. We don't have the expertise either. Courts don't have the expertise, and I don't think that the state AG has the expertise to develop such a framework to be practical enough.
Jay, I'd like to get your thoughts, and the way I've sort of framed this issue for myself is this is a significant peel back on refusal to deal or requirement to deal federal law, right? I mean, I think the combination of not requiring monopoly power or something akin to monopoly power, and of what may be a very low standard of market power showing, will put lots of firms in the position of having to potentially deal or contract with firms that they otherwise would not for perfectly reasonable reasons, just because of the uncertainty around this. But what do you think?
So I'm not a lawyer, and I read the single firm conduct's proposed legislation language. I don't really understand what it's. I mean, I understand what it's trying to do, but it is basically a blank slate. The Sherman Act that Congress passed in 1890 was kind of a blank slate, and over the past 135 years, courts have tried to fill in the blank. I think it was imperfect, but we have a lot more structure. We have a lot more doctrines and rules about what is a violation of antitrust law, what's not. We have certain requirements. We have the monopoly power threshold for Section 2. This proposed legislation basically says, here's a blank slate, create a whole new case law around it, but don't follow federal courts. And whether the California courts have the capability or the know-how, or the state AG has the know-how or ability to do this, is it's kind of irrelevant, because it took a very long time for federal courts to come up with something that's not that great, not that perfect, but it's something. And having California go through the same exercise, I don't understand how this would actually work. And if you're a company and you're dealing with somebody and you don't want to deal with them, you don't want to sell them your valuable capacity, or at least your valuable capacity to them for the terms that they are asking for. Am I violating antitrust law? Do I have a refusal to deal? To me, this is anathema to antitrust. The idea of antitrust, that this is, I am trying to compete as hard as I can to make money for my shareholders and to deliver value for consumers. And now all of a sudden, I have all these very vague potential requirements. Am I going to be punished if I succeed too well, or if I refuse to deal with somebody who wants who wants access to my assets? That's not free market competition. I think that's the biggest problem with this proposal is it just injects so much uncertainty and potential requirements that take you away from free market competition. Maybe Barak doesn't like this term, but I don't have any better way to describe it.
Let me attempt to sort of narrow some of the concerns, right? I mean, I think, look, I mean, I believe it's clear from the recommendation, what I'll call recommendation report, that the commission believes first that the state courts can call on federal antitrust law that is not inconsistent with the judicial guidance that the commission recommends be adopted, which includes sort of the rejection of those cases I mentioned early on, right? I mean, I believe the commission believes that the rule of reason will limit the requirement that a firm deal with all comers or all requesters, right? I think where the uncertainty develops, at least in part where the uncertainty develops, is that decision to deal or not deal with certain firms, or to deal or not deal only on certain conditions, right? Has been moved from sort of a monopoly power standard, a monopolization standard, to a restraint, or what you might call a market power standard, right? I mean, usually in federal law, if you don't have market power outside of per se violations, you are not found to be engaged in an illegal restraint or an unreasonable restraint. But of course, there is a big difference between the standard for finding monopoly power and finding market power, or something like market power. The commission's report suggests to me that market power might be found at something as low as 20%. But even if you accept, what federal law might suggest of 30, 35, 40%, that is a significant difference than the 60, 70% that is probably the minimum requirement for finding monopoly power. And thus, this will sweep in a significantly larger number of firms that may have some duty to deal with other firms, other customers, and on the conditions they deal with, right? So think about the grant of exclusive distribution territories. Think about the grant of an exclusive license to use, intellectual property. Firms that have an asset that allows for some grant or respect of exclusivity to themselves may now be in a much weaker position to deny access to that asset or product to others. And this, this goes well beyond the allegedly dominant, tech firms into firms in many industries. It basically extends to market leaders in most firms, I would think, unless those markets are highly fractured. But Barak, I do want to move on to sort of the Section 2 like part of this recommendation. But what do you think? I mean, it's not that there's no guidance. It's just that it is a much lower threshold than exists today.
As you were speaking, I thought about it. You refer to the rule of reason, and I think it is related to everything we've said so far. So, in my mind, one of the most important and most valuable development over the past 3 decades was the burden shifting framework that has structured analysis, added consistency, and considerably improved the flow of cases. And rule of reason is kind of one of the elements. So, when you remove the market power, you basically flip the threshold of prima facie case, step one, and then you have the other two and three steps. So basically, it's not just kind of blank slate of let's try to do things with the rule of reason, because rule of reason is now very, very structured. This is completely clash with the way antitrust is both understood and practiced. And there's a lot to say about people who think that that can be done. So, the question is whether they do not understand how antitrust is practiced, or they think that it can be recreated from scratch in a very complicated economy. And one thing that always comes to my mind with the duty to deals, let alone that it is inconsistent with American jurisprudence in general, is what does it mean for a company like Netflix, that out of the sudden Netflix will have to carry every content of every party that has. So again, it is not really. There's a good reason why we have the freedom to deal. Originally, came from we don't want to have restraint of trade, but how could you actually implement it? So again, for me, both the economics and the practicality is severely lacking, including the notion of complete departure from the standard structure of legal analysis, which is right now the burden shifting framework.
Barak, let me ask you, I do want to move on to the Section 2 like kind of, but even the burden shifting framework is a little bit unclear. You probably recall that the Justice Department in the Biden administration wanted the courts to adopt a balancing requirement at the end of the sort of Section 1 structured rule of reason analysis. Um, it it may seem intuitive to people that Section 1 burden shifting rule of reason includes sort of a balancing requirement if you make it all the way through. But I believe the Supreme Court has been pretty clear that uh, Section 1 does not require balancing. It has a sort of, prima facie case sort of requirement on the plaintiff and some undercutting of that case by the defendant. And then it moves to sort of the least restrictive alternative test, where the burden is on the plaintiff. And that is, in fact, not very plaintiff friendly at all. So but it is unclear, right, how courts will sort of, even if they adopt sort of the structured rule of reason approach of federal Section 1 law, even if they can discern what that means, it's not clear that requiring parties to go through this structure, uh, absent monopoly power, is going to lead to clear case principles, right? I mean, I think one of the problems here is it just opens up the number of cases, number of firms who are going to have to deal with the uncertainty of what is reasonable, where you come out at the end of a rule of reason sort of approach, right? And, you know, the requirement of monopoly power to evaluate single firm conduct may or may not be perfect, but it does have the effect of limiting sort of your sample or population of firms that will be captured in this uncertainty, right? I mean, I think that's a significant issue that the state the commission did not deal with, which is basically, notwithstanding this, rule of reason, it is not entirely clear what that means, and how you get over your respective burdens of production of sort of evidence in support of one position or the other. Anyway, maybe that's just maybe I'm just repeating myself, and maybe it makes sense to move to what I'll call the section 2 like component of statute. So in the first instance, the commission largely recommends the adoption of a section 2 Sherman Act section 2 prohibition. It makes 2 changes: one to make clear that monopolization violations also include monopsonization violations, so buy side as well as the sell side. They also include a monopoly maintenance claim, which seems unnecessary, but I don't think especially harmful with respect to the text of the text of statute. But the commission does recommend that state courts do not follow, in a sense requires they do not follow principles developed in a handful of cases that in effect either short circuit a sort of rule of reason analysis or stand in the shoes of a rule of reason analysis by either adopting a specific effects-based test or conceptually extend or reinforce Colgate's, right? The ability to, not refuse to deal with some firms. So let me put it specifically. The commission did not like the rule in Brook Group, right, which is the predatory pricing, which formalized the rule for predatory pricing, meaning a price below some measure of appropriate cost or appropriate measure of cost, and the ability, not the actual recoupment, but the ability to recoup, right, which to me is sort of an entry barrier type question. The commission suggests, one, that's a bad rule. In particular, it's a bad rule because we have zero price markets now, right? We have products that don't have a price. So let me ask, what do you think about the rejection of Brook Group by the commission in its recommendation?
Is this for me?
Jay, why don't we start with you?
Sure. So I think that this follows a concern that Brook Group basically removed the ability to bring predatory pricing cases, which is probably correct. That bringing predatory pricing cases is hard, but it rarely occurs. Successful predatory pricing cases, but I think you have to ask yourself, what's the problem? Is there rampant predatory pricing that is creating powerful monopolists? I haven't seen anything to suggest that's the case. And Brook Group was particularly concerned about forcing companies to price higher just to avoid the risk of having a predatory pricing case. As far as zero pricing, I don't see how that's relevant here at all. Zero pricing occurs in the context, normally of platforms, two-sided markets, and this is having zero prices does not make it harder to bring. That's not the reason why predatory pricing cases don't work. This is, to me, a red herring. But the idea is, do they want lots more cases of predatory pricing? In fact, they actually suggest that you could have predatory pricing cases when defendants are pricing above cost. It's not just about recoupment. So that's going to introduce a lot more uncertainty about your pricing decisions and probably cause some firms to price higher. I think my view is if they want to do that in California, have consumers pay higher prices in California, that's their prerogative. I mean, that's our federalist system. It sucks for California consumers, but the rest of us who don't live in California don't have to suffer the consequences. Some of the other provisions of the proposed legislation, such as, I would say, what we talked about earlier, limitations on refusal to deal, forcing companies to deal. I think that will have repercussions way beyond California, which I think is much more problematic. If California wants to allow much easier paths to predatory pricing challenges, okay, well, I mean, it's the wrong move. It will harm consumers of California, but maybe this is, in their view, the right way to go.
Barak, any sort of reaction
So
on?
I think and I may be wrong about it, but I think that the issue is not Brook Group itself, because they did not get into the mechanics of what is the threshold of below, what is that make it predatory. Because we can argue whether it should be average pricing or whatever. That's not the issue. They did not talk about what does it mean recouping, which is the issue. So I think that again they were inspired by sentiments of the kind reflected in the congressional report about digital markets, that digital platforms with zero pricing or low pricing engage in predatory pricing. That's kind of the neo-Brandesian approach. And I think that that's kind of missing the business model. And that's why we have decisions such as Amex that just expand the market definition. So I don't think that it is I think that it is all about digital platforms or driven by digital platforms. And I think it doesn't really address what is the business model, which it is true that we don't have good standards for that, but prohibiting a so-called predatory pricing will be ineffective. So just kind of a simple example. So Jay said, okay, the prices in California can be higher, but the rest of us will pay lower prices. So what does it mean for streamers? That people in California will start using VPN so that they will pay the prices, higher prices, lower prices, etc. I think that again, in the context of digital products, for example, it is going to be ineffective. And I think that the real issue is, okay, what do we do in the market with very powerful intermediaries that operate in multiple markets? And we should do better than that, but it will not come with a very simplistic solution such as duties to deal and prohibiting have a very broad definition of what is predatory pricing.
But okay, so the VPN issue, that's an implementation issue. I think this is what is going to make these kinds of laws difficult, and I think that's a real impediment. But to me, the bigger question is what is it that you're trying to address? What is the problem that you're trying to solve with some of these alternative provisions, in predatory pricing? Is it that you're trying to somehow rein in. If you want digital platforms to start charging prices, to start charging positive prices, you don't need antitrust for that. You could just say, you could just regulate their pricing. I think using antitrust for something that is non-antitrust related is an abuse of antitrust. I think, and with this legislation, with the proposals to make predatory pricing cases easier to bring, what is it that is the goal? This is what I don't understand. I think they probably need to explain that better.
Well, I think so. So Barak, let me respond a little bit to what both of you said, but maybe put this question to you for a quick response, because I want to sort of close this out. Predation is not the only claim you can bring with respect to pricing decisions, and the Commission itself recognizes, by reference to the ZF Meritor case, that predation claims really are sort of a subset of exclusionary, exclusion or exclusionary act cases, and exclusion cases do not require sort of this quantification of above, below cost pricing and the ability to recoup. So I thought the way I sort of described the restriction on using Brook Group is to me a very good test for single product pricing kind of discounting decisions. When you move out of single product positive pricing discounting type cases, it doesn't work very well, which is why you don't use Brook Group in loyalty discounts, bundle discounts, things like that, right? Multi-product or multi-volume tiered discounts, right? You use sort of the more general framework of exclusionary conduct, right? So to me, they're throwing out a very good rule that for a certain thing, because of a concern that it is used incorrectly in other matters, or that is the only tool with respect to discounting and pricing kind of conduct cases, right? It seems to me the general exclusion framework works in zero price markets just as well as it would anywhere else.
I think that I generally agree with you. Perhaps I'm less excited about Brook Group, but that's, again, I don't think that the issue is the details of the Brook Group. It's rather come more in kind of the contemporary economy. And there are plenty of things that perhaps are not real platforms, but still have zero pricing for entry level. So in digital economy, blitz scaling is very common. So all the Gen AI platform companies have a tier of free pricing. Now, can they recoup it? Perhaps, they hope so. Some of them will not succeed and will go bankrupt. So again, we have zero pricing or we have below cost pricing for many aspects or for many business strategies, which again, you need to have some rules for that. So it is true that the rules we had in the 20th century were for a single product. Whether they're good or not, that's a separate thing. But here, I don't think that it is kind of a concern that is not articulated, as Jay said. What do you try to accomplish in the contemporary economy? And there was a simplistic fixation with low prices or prices below cost, which are perceived to be unfair. But again, I agree with both of you. There is no clear definition. What do you want to accomplish? And what is the actual legal standard that courts can administer? And I think that both these aspects are fundamentally missing. And when they are missing, you cannot come up with good legal standards.
So in the reference to legal standards, let me ask, the recommendation rejects, or in a sense recommends that the legislature reject the use of the no economic sense test and the equally efficient competitor test as a framework for resolving monopolization claims, right? So this is in a sense not a case-specific rule like Brook Group and maybe Trinco or Aspen Ski, It is a framework, right, for distinguishing between conduct that may or may not cause harm, with maybe a preference for protecting against type 1 error. So what do you think about this this rejection of two tests that are used in the case law, and at least for some significant period of time, were the policy of the Department of Justice, right? Most of their monopolization cases can be what sort of fit into a no economic sense framework.
So I think that I kind of like the economic sense framework. I'm less enamored of I think that the equally efficient test and what was the other one? Um, Profit
Equally
sacrifice.
yeah.
Yeah, I mean those are a little bit more vague. I think going back to predatory pricing and refusal to deal issues, I think the common theme is that that what they're sort of trying to push for is competition that tries to accommodate weaker competitors, giving people a little bit more of a crutch, um, sort of equity among competitors. And they use language like fair. It's funny that sort of the preamble, the description of what they're trying to achieve is free and fair competition, which to me are it's kind of an oxymoron because free competition is not fair. Some firms are some really much more efficient. They have more IP, more scale. They just have better people. They're just better at business. And what this is trying to get at is, well, you know what? You don't have to be as efficient, and just because it doesn't um, it makes economic sense for you to beat up on your competitor, well, maybe you shouldn't do it. That seems to be the theme. I think that this is not antitrust. This is sort of managed competition. But Barak said, sort of criticized the proposal for being sort of out of touch and disconnected to antitrust case law. I think it's not a bug, it's a feature as far as this line of this philosophy is concerned. We want a different vision of competition, antitrust, where competitors beat up on each other. Well, why, you should try to be nicer. You should accommodate. You should, maybe not refuse to deal with somebody who needs your help. I think I think that ultimately this is not going to succeed. I think the way the proposal is written is too vague to implement in a meaningful way. The courts are going to have to come up with something that will force them to separate true acts of harmful anti-competitive behavior from having to accommodate your competitor. And there's also no limiting principle. Like, if you have to be nice to your competitor and accommodate them, this is like, going 50% of the 50% of the way to price fixing. So like, where do you stop? Anyway, Barak, I don't know if you have any thoughts on this.
No, I think I generally agree with you that it seems, and I think it is difficult to argue, that the spirit is free and fair competition, which I could not agree more with you. Competition is inherently unfair because there are winners and losers. And I would go even one step further. In antitrust, competition is the threat. If you do not innovate, if you do not differentiate, you will face the brutality and pain of competition where markups are shredded and eroded. Therefore, this is the real function of antitrust law. You do not want to be in a situation of really ruthless competition because it is awful. Come up, innovate, come up, differentiate. This is what we offer you. And it has worked, it's imperfectly. People can criticize different standards, different time, etc. But overall, we are not going to be in a position that everyone is happy and we live in kumbaya. That's not competition inherently. So I couldn't agree more with you. And I think that your point is fair. I mean, it is very abstract. It is utopian without any specification that can be operationalized into legal standard. You call it limiting principle, but where are the legal standards? Not let alone where is the economics?
Can I take maybe each of you a minute? Was there an alternative to the recommendations that you would support, right? Is there something that maybe California could have done or might still do that would be more effective in addressing their concerns about either the development of monopolization law or the outcome of monopolization cases?
All right. So I'm not sure what their concerns are. If their concerns are that current antitrust is bad because it is too rough of a sport, as Barak described, and I totally agree with your analogy. Then I think that it could have come up with something more clear, but I would have very much disagreed with that version of alternative sort of specification, alternative law for single firm conduct. I think where antitrust law in Section 2, single firm conduct, can benefit is for more clarity and more internal consistency. I think that's, to me, the biggest issue. But obviously, they went in the opposite direction.
I agree with everything that Jay said. Let me just add one tweak, is that I feel strongly that state laws do not help much for antitrust, and it's better to have federal law. And keeping in mind that there are dissatisfaction with Section 2, whatever those might be, you just invest in your antitrust team in the AG office, and the state AGs do very good work, or good or not in Denmark, they do work and they can influence. So if you have concern, try to move forward, try to move the needle through Section 2 cases that are initiated or run by the state AG. I'm not a fan of state laws.
I'll just quickly summarize that by saying there's probably nothing in federal law that prevents the articulation and enforcement of a good case. But what does seem to restrict the states is the resources to bring those cases. I also think it will be good if these cases came to the merits trial more quickly than they do today, right? I mean, while I have questions about the cases against Google, the merits of the case against Google, clearly the delay, the time that passed between filing complaints and the merits decision and remedies decision was affected by changes in the market. Okay, Glenn, we'll turn it back to you.
Thank you, gentlemen. Definitely enjoyed the conversation. I think there's a lot to sort of chew on here. I hope that the message gets out to those who are going to be looking to potentially put this into law in California. It'll definitely be an interesting discussion as this goes forward. And I think you all did a great job of encapsulating some of the concerns and issues that are going to need to be discussed as this goes forward. I want to thank Barak and Jay for their participation. Bilal, thank you for being such a capable and outstanding host for us today. And let's everyone know that if you joined us late or you know someone who might want to watch this or you'd like to watch it again, it'll be available on our YouTube page and I will send out an email to everyone who registered to make sure that they have a chance to watch that, and encourage our panelists to send that around as well. Thank you again for joining us.